So today we'll be discussing ex parte reexamination filings, specifically with EFS-Web. But before I get into those topics, I just want to briefly introduce myself and introduce Ashley and her company as well. So I'm Kevin McNish. As Ashley said, I was most recently a partner at Damaris LLP, was the head of their post-grant group, left to launch McNish PLLC on my own back this fall. It is a cloud-based patent office and Federal Circuit boutique firm, currently headquartered in Long Island City, New York, but moving to Southern Maine in 2021. So I represent clients in inter partes reviews, post-grant reviews, ex parte re-exams, and related appeals to the Federal Circuit. Next, Ashley, with whom I put this webinar together, is the head of Virtual Patent Gateway LLC. She provides paralegal support service for patent professionals. One of the services she offers is virtual PTAB paralegals, and I have to tell you, when I started my practice, I looked high and I looked low to try to find this service offered by anyone else, and Ashley was the only one, and even if she weren't, she'd be the best at it for sure. So I'm really looking forward to working with her and continuing to work with her, and she's great, and really I don't think needs any further introduction, but feel free to chat with me or her afterward. So what this webinar is about today is ex parte reexamination filings, and specifically with EFS-Web. Our goals for today are first to get you familiar with the procedural requirements and filing practice using EFS-Web specifically for ex parte reexaminations. And secondly, to provide an introduction to the patent owner side of that world as well. Most of this webinar today will be focused from the perspective of a third-party requester filing a request for ex parte reexamination. The rules for patent owner filed reexaminations are generally similar with a few small differences, but the scope of today will focus principally on third-party requesters filing ex parte reexams. The reason this is an important topic is we are starting to see a resurgence of ex parte re-exam filings. There's any number of reasons that can explain that. Some of that is, frankly, they're a lot cheaper and can be put together much more quickly than a full-blown inter partes review. They are also less susceptible to discretionary denials than inter partes review petitions are. So a lot of people looking to challenge patents are also looking to do so via not just IPRs these days, but also via ex parte re-exams. We're also starting to see some use of ex parte re-exams by patent owners in instances where their patent has actually gone through an IPR. The Patent Office provides some procedures for filing re-examinations and reissues should an inter partes review result in a claim being held unpatentable in a patent. And there's some procedures on that that are a bit beyond the scope of what we're going to discuss today, but that's another reason we're seeing more of them from the patent owner side as well. So to just introduce reexamination at a high level, it's a procedure by which a patent owner or a third party can request the USPTO to re-examine an issued patent. The request must raise a substantial new question of patentability based on prior art patents and printed publications. Now, that's a little broader than what's available in IPR. In IPR, you're limited to anticipation and obviousness over prior art patents and printed publications. Unlike an IPR petition, you can actually raise double patenting in an ex parte re-examination. Generally, once the request is filed, the proceedings are limited to the patent owner and the USPTO. There are a few exceptions in which the requester gets additional participation rights. Usually that's triggered by something the patent owner has done or filed, but for the most part, after the request, the requester is done and does not significantly participate any further. Turning to the next slide, EFS-Web is the USPTO's filing system for patent applications and other ex parte proceedings, for example, reissues or new patent applications. It is an older system. It's been in place at least since I was in law school in 2010 and probably considerably earlier than that. The USPTO is starting to take steps to replace it with Patent Center, which has a much more user-friendly interface. As of 2020, though, Patent Center is still in beta, and while much more user-friendly, does run into some reliability issues. So it's important to know how to use EFS because for all of its problems, EFS is a fully developed system. It's not in beta. They have mostly worked the bugs out. And it's a fairly straightforward process, albeit a little clunky. But we're here today to make it a little less clunky for you. So first, we need to discuss who can use EFS-Web. The use of EFS-Web is limited to registered practitioners who can practice before the USPTO, people with reg numbers, or people that are sponsored by registered practitioners, such as paralegals and other support staff. For a registered practitioner to sponsor support staff, first the paralegal or legal assistant needs to set up an account with my.uspto.gov. You'll also need to enable two-factor authentication for that, and that simply refers to anytime you log into your uspto.gov account, you'll be sent an email with a one-time code, or if you have an authenticator app like the Google Authenticator or like Okta, you can use that to generate a 6-digit code and use that as another login factor on top of your password. For registered practitioners, you will actually need to sponsor your support staff before they can actually do any filings for you. You can do that at the link I provided in this presentation, and we'll circulate that afterward as well. It's a pretty straightforward process. All you need to do is go to that website, give the USPTO the email associated with your support staff, and click the sponsor button. Support staff will then confirm it, the sponsorship, and then you're good to go. So there are three principal topics we're going to be covering today within filing reexamination documents using EFS-Web. And they roughly sort into three areas. Before you file, that is preparing and gathering documents, the actual filing process, filing an ex parte reexamination request using EFS-Web, and this will be from the perspective of a third-party requester, and then filings after the request, and that includes basic things that a third-party requester would file, things that the patent owner would file, and while there's less for a third-party requester to do, it is important to know when you can file and when you should file documents to respond to patent owner documents. So I refer to the preparing and gathering documents process as using the phrase mise en place. It's a French cooking term. It just means having all of your ingredients and cookware in the right place and readily accessible, so that as you start cooking, you're not rummaging through the fridge or rummaging through cabinets to find the right ingredients or the right cookware. And this is an important process. This is something you should aim to do at least the day before filing, if feasible. If not early morning, the day of, you're going to do it. And you'll find that having lined up everything in advance and having everything taken care of in advance makes for a much more pleasant filing process. And so what I'm going to be providing in this section are both some required practices and required documents that the USPTO requires you to provide and requires you to follow with respect to your filings. I'll also be providing some of my best practices just from having represented clients in re-exams and having found what worked well, what didn't work well, and passing that along to you so that you can make use of that. So This next slide, this checklist for filing, is something that you can use for any re-examination filing. You'll need the following: a cover sheet, a request for re-examination, some required supporting documents, some recommended supporting documents, a certificate of service if you're a third-party requester, and then the required fees. So this slide, again, as you're assembling documents, as you're putting things together, use this slide as a checklist to make sure that you have everything you need, everything has been prepared, things that need to be signed have been signed, things that need to be filled out are filled out, and that way you're not running around during a filing trying to scare up a document, trying to get something filled out, losing version control, all of those things. The goal is to have a peaceful, serene filing, and by following these practices, you should have a pretty straightforward one. So the cover sheet is, again, just a checklist for your checklist, really. And it asks for some very basic information, things like which patent is to be re-examined, which claims, who the requester is, and some fee information, including whose deposit account should be charged for the fees for the re-exam. Now, I've noted on the slide that the requester identity is optional. Re-examinations can be filed anonymously, so the requester can actually be left blank. The other thing to point out is that third-party requesters can qualify for small entity status. Patent owner requesters can qualify for both small entity and micro entity status, which provides discounts on the re-examination filing fees. So turning to the request for re-examination itself, this is your centerpiece for your re-examination. This is your brief. Essentially, its analog in the IPR world is the petition. There are 4 components that absolutely must be included in every re-examination request. Those are a statement pointing out a substantial new question of patentability, and that's must be based on prior art patents and printed publications, an identification of each claim for which re-exam is requested, an explanation of how to apply the prior art to each claim, which can be done in either prose or claim charts, and a certification that there is no estoppel from a final written decision in an IPR or a post-grant review or a covered business method review. So if you have those 4 components, you have a re-examination request. Now, on the next slide, I've listed 2 items that are recommended but not strictly required. One of those is an exhibit list, and I will get into that a little bit on the next slide. And the other is an explanation of how to construe the claims in light of any patent owner statements. So with your re-exam request, you can file documents that the patent owner has filed either in the patent office or with the PTAB or in litigation that make statements about the scope of their claims. So that can include things like claim construction briefs, that can include things like PTAB briefs that raise claim construction issues, that can include arguments about the same term in related patents. All of those things can be filed with the re-examination request, and if you're using those to present claim construction arguments in your request, you must file those with your re-examination request. I want to spend a little more time on the exhibit list. This is something that I found is really just kind of a best practice, and I will use IPR style exhibit list for my re-exam filings. And the reason I do that is it helps me organize all of my documents, it helps me write my request, it helps direct the examiner very quickly to the requisite prior art references that I've cited. So my usual numbering scheme, again, similar to an IPR, the patent to be re-examined is Exhibit 1001, the file history is Exhibit 1002, and then everything afterward is fair game. That can be expert declarations, prior art references, claim charts, you name it. If you're filing a second request, as the example exhibit list in the slide shows, I always start with Exhibit 1101, and that's, again, keeping with IPR practice. One tip I found that is very, very useful for this is don't assign firm exhibit numbers until the end. I will usually use placeholder exhibit numbers for any exhibit that I refer to by a number, for instance, EX10XX, as I'm putting together drafts. And then the other thing I do is when I am referring to expert declarations or prior art references, I will usually give them a name and then cite them by name in the request itself. You can see that, for instance, in exhibits 1103 through 1108. In this example exhibit list from a re-exam I filed about this time last year. And what that does is if I start changing my mind on how I want to present references, or if I need to insert new references, I can keep my exhibit list. I just have to change my exhibit list. I don't have to change anything in the brief. I don't have to do any Control F5 in workplace to fix exhibit numbers. So next, in addition to the required components of the re-exam request itself, there are also some required components, required documents rather, that you must submit with your re-exam request. One of those is copies of the prior art patents and printed publications that you're citing in the request, and that's even if they're already of record in the patent. For any foreign language references, you should include translations of the necessary and pertinent portions of those references. Just as a matter of best practice, it's best to go ahead and submit the entire thing. Usually you'll want to get a translation of the whole reference anyway, just to make sure that there aren't any portions that are untranslated that are unhelpful to your position. Unlike an IPR, it doesn't have to be certified, but if you're getting a certified translation anyway for litigation or for another reason, feel free to go ahead and submit a certified translation. The other thing you need to submit is an IDS, an information disclosure statement, and that simply lists all of the prior art patents, printed publications, and other materials that you're citing in the request, and that those other materials include declarations, translations, and patent owner statements. The general rule of thumb when you're filling out an IDS, it's just a table that lists patents, patent documents, U.S. patent documents, or other foreign patent documents in the non-patent literature. If something doesn't fall into the first two categories, just throw it under the non-patent literature category and for the examiner to consider. The next set of required supporting documents you need to provide are first, a copy of the entire patent to be re-examined, including all certificates and disclaimers. One practice tip here, Google does not always have the certificates and disclaimers. For instance, if there is a certificate of correction or a previous re-exam certificate or an IPR trial certificate. So make sure you are getting your patents from PATFT, it's the USPTO site. It's patft.uspto.gov. You click on images after you put in the patent number, and you can then access the entire patent as it's maintained at the USPTO. Make sure you're getting disclaimers as well, so that you've got everything that's required by the regulations. For third-party requests, you also need to provide a certificate of service on the patent owner. And we'll see what an example of a certificate of service on the next slide. I'm sorry, 2 slides from now. Before we get to the certificate of service, let's talk about recommended supporting documents. And again, none of these are strictly required. They are very good ideas to include, best practices to include, and you would do well to include them. So the first is a copy of the patent's file history in its entirety, and you can just get that from Patent Center or from PAIR. The reason you should include a copy of the patent's entire file history is that's how you're going to show there's a substantial new question of patentability. Something was not addressed during a previous examination or previous proceeding involving the patent, and the references you're submitting raise a new question. A very common way of raising a substantial new question of patentability is to identify the last claim amendment that prompted the examiner to allow the claims. Usually the patent applicant adds some limitation and the examiner says the newly added limitation is not in the prior art. And if you have prior art that teaches that newly added limitation, there's your substantial new question of patentability right there. That's a very common approach, very easy way to do it, and that's why you should include the file history. Additional materials you can and should include, but don't necessarily have to, are declarations, expert declarations interpreting the prior art, librarian declarations in case there's any dispute or potential dispute about the public accessibility of a reference, particularly for non-patent references. Claim charts summarizing each proposed rejection to the extent you don't have them in your request already, and litigation claim construction orders. And the reason you want litigation claim construction orders is they help show the maximum or that the broadest reasonable interpretation of the claim encompasses at least what took place, or at least how the district court construed the claims. In re-examination, broadest reasonable interpretation is still used in contrast to district court litigation, which uses the narrower Phillips construction. If there are any prior claim construction orders by the PTAB under Phillips, for instance, in an IPR, or any decisions construing the claims, you can include those as well. Next, certificate of service. The certificate of service is a very important document because you won't get a filing date unless you can prove service of your documents, your request, and that actually goes for any documents that either you as the requester or the patent owner file. You always have to serve a certificate, file and serve a certificate of service. So in this particular example, certificate of service, this lists the references that I had cited in this previous re-exam. You need to list every document you filed with the USPTO, including the certificate of service, the method of service, and the name and address of every party that you served. For your initial request, you should serve the patent owner as indicated at the correspondence address in PAIR or on Patent Center. It's also a good idea to serve litigation counsel. You can do that either by mail or electronically. And looping back on the method of service, one of the things about re-exam is it's a little flexible about service. While you need to physically send the documents that you're serving via FedEx or UPS or US Postal Service, but you don't actually need to send a full mountain of paper. You can just burn it to a disk, send a flash drive. Either of those is generally acceptable. And finally, fees, the last required component. Generally, if your request is longer than 40 pages, you're going to be paying full freight, which for a large entity is $12,600. If you have a request that is shorter than 40 pages and adheres to certain other typeface and spacing requirements in the regulations, you get a 50% discount. And then you get further discounts on both of those prices if you're a small or micro entity. So once you've gathered everything, put all of your documents in one folder. This will save you a lot of heartache later. Going back to my analogy, this is like having all of your ingredients ready to go on the kitchen counter as opposed to having to rummage through the fridge and cabinets to get your ingredients. For all of your exhibits, once you have an exhibit list finalized, put a slip sheet at the front of each exhibit with its exhibit number, and at right you see an example slip sheet. If any of your exhibits, once slip sheeted, exceeds 25 megabytes, you'll need to split it into multiple parts and then put a slip sheet on each part. So for example, exhibit 1001 part 1, part 2, et cetera, et cetera. The reason for that is EFS has a file size upload limit of 25 megabytes, so you can only, if you've got a file that's bigger than that, you're going to need to break it up. So, having gathered everything, the first thing you're going to want to do is convert any PDFs that you have into PDFAs. PDFA is a specific subtype of PDF format that generally will embed fonts and will help you avoid some of the most common errors that come up during EFS filings. It's the most straightforward way to do it. The other option is if you can't get your document saved as a PDFA, what you should do is print it as an image PDF. and that will also solve your problems usually. And so if you want to save a Word document as a PDFA, this is a special case. You actually don't have to go into Acrobat to do that. You can do it directly from Microsoft Word. And you see the options that you can select here to save directly as a PDFA, and this will embed your fonts and help you avoid a lot of the problems that come up with non-embedded fonts, which we'll be discussing in a little bit. Okay, so now you've gathered all of your materials. They're all in one folder. It's time to start cooking. It's time to start filing your reexamination request. What we're going to have on the next couple of slides are a series of screens to walk you through an example reexamination request filing using EFS-Web. And these will be very useful for when you're filing your own EFS, your own reexaminations using EFS to walk you through it as essentially a manual. So the first thing you need to do is to log into EFS. Generally, the way you'll do that is log into my.uspto.gov with your account, and then proceed to the File Patent section. That's what will take you to EFS. When you're preparing to file a new reexamination request, the menu selections to do so aren't immediately intuitive. So what I've done here on this slide is show you the selections that you'll need to make in order to file a new third-party request. So at the very top, you'll see that there are a new application button, then a utility application button, and then a re-exam button, followed by a drop-down menu to select whether you're a third party or a patent owner. Before you get to that, though, you'll need to either certify that you are the certificate holder or that you're working for the certificate holder. That's a certificate that allows you to access USPTO systems, and that is why you sponsor support staff. So if you're the actual practitioner, certify that you're the certificate holder. If you're working for them as support staff, certify that you're working under their authority. So this is the very first screen that you'll see when you start filing an EFS. So in the next slide, you'll be asked to fill out the title of the invention, the attorney docket number, which is optional, but if you maintain one, fill it in, and then the first and last name of the inventor. You'll also be requested to provide a customer number or your correspondence address. This gives the patent owner and the USPTO the address at which to send you correspondence about the reexamination proceeding. So once you've gotten that filled out, go ahead and click continue. You will see that there is that application data and web-based ADS at the top. Go ahead and click the ADS. It will be attached to the PDF. That is for re-exams, actually that cover sheet checklist that you will have filled out earlier. So this is the first screen you'll arrive at having filled out the application data. It's the attaching documents screen. And you're going to be spending a good bit of time with this screen because attaching documents takes the longest of any portion of this filing process. So the attaching documents process is pretty straightforward. As you can tell by the buttons, you essentially choose a file, choose a category, and then choose a description fitting that category. And if we have any Brian McKnight fans here, back at 1, it's not too different from that. 1, choose a file. 2, select a category and document description. 3, click Add File to add another file. 4, repeat steps 1, 2, 3. And then step 5, click Upload and Validate. Now, between step 4 and step 5, there's a step 4.5, which is often pray, because sometimes EFS can be a little fickle about accepting your files. We'll get into some common methods for troubleshooting a little later on. So for your cover sheet, it's straightforward. Just click General Transmittal and Transmittal of New Application. This is what you'll be filing the cover sheet under. So you'll select your cover sheet and then pick your category, pick your document, and then click Add File, and then go to the next file. For the request itself, you have one of two options. The first is request by third party. The second is request by third party of less than 40 pages and compliant with the typeface rules in 37 CFR 1.20C1. The reason you need to select between those is it's how you calculate fees later. So next, you need to upload a copy of the patent to be re-examined. And so your category here is re-examination, and your document is copy of patent for which re-examination is requested. And you'll have copies of the slide presentation afterwards, so you can refer to this as needed for your own filings. Next, prior art patents. So this is in the IDS category, and generally you'll put this in the other reference. There isn't a separate category for prior art patents when you're submitting a copy of them with a re-examination, so it falls under this other reference category. Next, prior printed publications. This is your non-patent literature, and these are your references that are, for instance, journal articles, books, and so forth. Foreign patents, again, very straightforward. Go to the IDS category, go to foreign reference. If you've got any other miscellaneous documents, those are things like file histories, translations, declarations, claim charts, and litigation documents. Use the affidavit, declaration, or exhibit filed by third party category, and that's under, document description under the re-exam category. And that's really just kind of a catch-all for anything that is not a prior art reference. Finally, your information disclosure statement. You're filing a very special kind of information disclosure statement, which is a third-party re-exam statement. So go ahead and select the re-exam event information disclosure statement filed by third party. Now, you can actually just use the basic information disclosure statement form that all applicants use, or the patent applicants use as your re-exam IDS. That's not a problem, and that will be accepted by the USPTO. And finally, your certificate of service, again, in the re-examination category. And again, an essential part of your filing. You're not going to get a re-exam filing date without it. Finally, once you've attached everything, and here you can just see my little example request that I've included, you'll click Upload and Validate. What this does is it actually uploads your files to the USPTO servers. They haven't actually been officially submitted yet, but this process is used to verify your files. And here we got lucky. No validation errors have been found, and we're very happy about that. So we're going to go ahead and click Continue. I should note this is the best case scenario. Oftentimes you'll have to do some troubleshooting. And the most common troubleshooting issue you will run into, as seen in this slide, is the dreaded embedded font error. This is something that regularly comes up regardless of how well you're prepared. Something is going to have a non-embedded font, despite your diligence, despite working on making sure all your documents are prepared. So just be ready for this. So what you're seeing here is a screenshot of what happens when you've got the non-embedded font error. And there are a couple ways to address it. First, you're going to have to remove the offending file. So as the previous slide indicated, you'll need to remove it, and then remove it using the remove button at the far right, go back to the attach file screen, and then once you've cleaned the file up, reattach it. Then here is the order of steps I recommend trying to fix the embedded font error. First, if the PDF isn't a PDFA already, convert it to a PDFA and then reattach it. If that doesn't work, print it as an image PDF, and then reattach it. If that doesn't work, you have some license to say some bad words at this point if needed. I have once or twice, maybe. First, print the PDF as an image PDF, and then save the image PDF as a PDFA, and then reattach it. And finally, if all of those steps fail, and it has happened before, print a hard copy of the PDF, scan it, save the scan as a PDFA, and then reattach it. And hopefully by then you'll have resolved the issue. But try that as an iterative process, and ideally that will eventually go through. What I'm showing in this next slide is how to print image PDFs. This just requires tweaking your advanced print settings in Adobe Acrobat. So you'll go to just select the Adobe PDF printer, click the advanced settings. Under the advanced settings, check the box for print as image, and that's a way to print image PDFs, which should avoid the embedded font problem. One other issue that commonly comes up is paper size issues, and the Patent Office wants you to file everything in 8.5 by 11 or A4. If you run into issues with errors on that front, first double check to make sure your document, every page is in portrait rather than landscape. And second, if you have made everything in portrait mode, try using a shrink oversized pages setting. This will shrink your PDF document down to an 8.5 by 11 size. Once you've gotten through all your files and all of your files have passed muster, you're then going to go to the fee screen. The fee screen, first click calculate, and then secondly click continue once the amount of fees looks correct. And then turning to the next slide, you have two options. The first is that you can save for later submission. That doesn't actually submit it to the USPTO, but it does give you a way to access the filing later. For instance, if you want to save the submission for an attorney you're working with and have them review it, this is a good way to do that before filing. Many firms have sort of a two eyes approach to that, or two pairs of eyes approach to these filings. Kenobi, my first firm, did, and so this is one way to do that. But once you've had a chance to review, once everything passes muster, once everything looks correct, go ahead and click submit, and click submit only once. That'll then take you to the payment page, which I haven't shown here because that requires filing actual re-exam, and it's a pretty straightforward process in any event. If you have a USPTO Financial Manager account, log in and select a payment method. That can be a credit card, that can be a deposit account. You can also wire it. If you don't have a USPTO Financial Manager account, you can continue as a guest and pay using credit card at least. You may not have access to your associated deposit account since you're not logged in, but you can still pay by credit card that way. And once you've completed the filing, you'll receive a re-exam control number. This is how you look up your re-examination in PAIR or Patent Center, and this is how you file additional documents in it. You'll also get a 4-digit confirmation number, and you'll need both of those numbers to make any additional filings. So finally, just because you filed everything in EFS doesn't mean you're quite done. You do still need to serve the patent owner. Do so as described in your certificate of service. First-class mail is actually acceptable. UPS, FedEx, any physical means is acceptable. And instead of serving in paper, you can serve the like a CD-ROM or a DVD-ROM or a flash drive. But you do need to physically send those documents over. It's often a good idea if you have patent owner's email address or their litigation counsel's email address to serve an electronic copy. This shows that you've made all reasonable efforts to make service on the patent owner. So now that you've filed the request, there are, for a requester, a limited universe of filings you can make, but the bulk of the filings go to the patent owner. We're going to spend a little bit of time at the end here focusing on appellate filings before the PTAB, but for the most part, we're going to be focusing on after filing the requests for the patent owner. So after you filed the request, the USPTO has 3 months to decide whether the request presents a substantial new question of patentability and whether to order re-examination. As I alluded to earlier, with a few limited exceptions, usually triggered by actions of the patent owner, the requester doesn't get to file anything else during the course of the re-examination. So what I've provided on this slide is a 2-column chart that lists in blue things that the requester can file and things that the patent owner can file. And documents that can be filed earlier in the proceeding are listed toward the top of the page. Documents that are filed later in the proceeding are toward the bottom of the page. And we'll be going through timelines for filing each of these documents, as well as when these documents are even allowed to be filed. So first, you need to know how to file documents in an existing proceeding. That's why you need that application number for your re-exam, that number that starts with a 90 and is followed by a 6-digit number, and the confirmation number, that 4-digit number. Again, you're going to log in EFS, same as you would for filing a new request. This time you're going to go to existing application or proceeding, and then you'll enter the application number and confirmation number, and then click continue. And the very first document that might get filed by a requester is a petition from for rehearing of a denial of re-examination. So if the examiner finds that the re-examination request does not present a substantial new question of patentability, the examiner will deny re-examination. If that happens, the requester has 1 month to petition for rehearing. Other than that, that is the only further review of the decision to deny re-exam that is available to the requester. If the office grants re-examination, the patent owner can file an optional statement on the decision ordering re-examination. That statement can include a discussion of whether there is actually a substantial new question of patentability present, and it can include claim amendments. The patent owner has 2 months to do that. Now, most patent owners don't do that because a patent owner that files this optional statement, as you can see in the next slide, gives the requester the opportunity to themselves file a reply, or rather a response to that statement within 2 months. So most patent owners generally do not file the statement on the order to grant re-examination. Usually if they have any claim amendments to present or any statements on the substantial new question of patentability and whether one's present, they'll argue it in their first office action response. And at that point, the requester does not have a right to respond. Now, if you're dealing with a particularly sophisticated or aggressive patent owner, every now and then you will see a petition to terminate or vacate a re-exam. There are 2 main reasons a patent owner will try to file one of these. One is that the patent owner believes the requester is stopped from a final written decision of the Patent Trial and Appeal Board. The other is the patent owner believes the requester is harassing them, perhaps via repeated requests. A petition to terminate or vacate must, based on IPR, CBM, or PGR estoppel, has to be filed within 2 months of the decision ordering re-examination. And the reason it has to be filed in that time frame is after the period for the patent owner statement expires, it is the patent office conducting the re-examination rather than the requester requesting or attempting to maintain a re-examination proceeding. It's in the patent office's hands at that point, and the requester is not deemed to be maintaining or requesting at that point. Realistically, you should file these as soon as possible. They also, if you're a patent owner doing this, you'll also need to combine that with a petition to suspend the rules, because there are generally rules that do not permit a patent owner to file anything other than a patent owner statement until the S&Q decision comes in. If you are a requester and the patent owner files one of these petitions to terminate or vacate, the first thing you need to do is call the examiner and call the Central Re-Examination Unit, and you need to do that as quickly as possible. That's straight out of the MPEP, and you need to tell them you're going to oppose the petition. The reason for that is re-exams have to be conducted very quickly by statute, and the examiner will not necessarily wait unless you tell them, hey, I'm filing opposition. If you are going to oppose, you have 2 weeks from the date of service of the petition to file your response. So that's a somewhat more infrequent use case. More frequently, the patent owner is not going to be filing a patent owner statement or a petition to terminate. Rather, the first time the patent owner is going to show up is responding to a non-final office action. By default, the patent owner has 2 months to respond. That response period can be shortened to 1 month if there's concurrent litigation or a reissue proceeding or another proceeding that would warrant shortening the time frame. Patent owners can request extensions of time for their responses. The request for extension of time must be filed before the due date of the office action response. And for third-party re-exams, it's very rare to get more than a month. 2 months are rarely granted, and anything beyond that requires circumstances sufficiently extraordinary that you're almost never going to get it absent a natural disaster. Usually we're talking things like Hurricane Harvey. We saw a lot of requests arising from that, for instance. And you're going to need some pretty exceptional circumstances to get more than 2 months. As a practice tip, very often if you want 1 month, go ahead and ask for 2 in your extension, and you're more likely to get your 1 month that way as well. Finally, continuing with patent owner filings, patent owner does have a duty of disclosure if they are aware of other references, that may be material and not cumulative. They should submit those in an information disclosure statement. The usual IDS rules apply. Copies of foreign language references and non-patent literature should be filed with the IDS for the examiner to consider. Once there's a final office action in the re-exam, the patent owner can still respond. They can file a response within 2 months, again, shortenable to 1 month if there's a concurrent proceeding. And that enables the patent owner rather to cancel claims or to narrow issues for a prospective appeal. In some rare instances, the examiner, in their discretion, will consider additional arguments and may even allow the claims. Don't count on the examiner to do that. That's purely discretionary. The more likely use of these for patent owners is to narrow the issues for appeal, to cancel claims, or in some instances to adopt suggested claim amendments from the examiner to secure an allowance, which in the re-exam context is a notice of intent to issue a re-exam certificate. There's also a notice of concurrent proceedings. Unlike the other documents I referred to, these can be filed at any time. The patent owner is actually required to keep the office updated on the status of any concurrent proceedings. That can include litigations, that can include PTAB proceedings, that can include other proceedings at the patent office in which the patent is involved. The requester has the opportunity to notify the office, but is not required to. And finally, assuming the patent owner gets to a final rejection and is dissatisfied with the office action, the patent owner can appeal to the Patent Trial and Appeal Board. So these are the list of events that would be used in rough order. First, there's a notice of appeal filed. 2 months after that, an appeal brief must be filed. Assuming the examiner answers, a reply brief is due, I believe it's 2 months after that, 1 month. Check the MPEP and the regulations. And then finally, there's a request for oral hearing of an appeal to the PTAB. Assuming the PTAB decision is adverse, the next step is the Federal Circuit, and then you file a notice of appeal within the prescribed time from the final decision of the Patent Trial and Appeal Board in the reexamination appeal. And finally, the last thing to take away is remember that every filing needs a certificate of service, whether you're the requester or the third-party patent owner. If you're the requester, everything you file needs to be served on the patent owner. If you are the patent owner, everything you file needs to be served on the requester. So, make sure, and that can include even small things like updating powers of attorney, notices of concurrent statements. Make sure every single thing you file also has a certificate of service sent with it. And with that, we've got a little bit of time remaining. I'm happy to take any questions that the audience has. Otherwise, thanks for your time here. I appreciate it.
All right, everyone. So if you have questions, feel free to put them in the chat. I have a couple here for you, Kevin. The first one is, I have seen exhibit number for re-exam to be exhibit A, AA, AAA, etc. in previous filings. Does the PTO allow us to use the PTAB exhibit number convention? I just want to confirm there's no issues.
Yes, that is allowed. It's a matter of personal practice. It varies from firm to firm and company to company. But the IPR style is generally accepted at the PTAB. I'm sorry, the PTAB style is generally accepted in the ex parte re-exam context.
Great. The next question is, what kind of evidence is needed to show harassment?
So usually what that's going to be is a second re-exam request. And that second re-exam request is substantially identical to the first one. And not even in, say, a general plastic sense where you're fixing some changes, but it looks like that the requester is not really presenting anything meritorious or anything that necessarily presents a substantial new question of patentability, but rather is simply burying the patent owner in protracted additional re-examinations on substantially the same issues. So the S&Q requirement does generally guard against that because, again, if there is a first re-examination and then a second re-examination, the second re-exam has to show an S&Q not over, or has to show an S&Q over all previous proceedings, including the first re-exam. So usually the S&Q requirement guards against that. Every now and then a patent owner feels aggrieved and feels they weren't adequately protected. And we'll try to show there's a substantially identical challenge that the PTAB or the office has already addressed and addressed fully and addressed in the patent owner's favor.
Regarding service of the as-filed documents, is there any rule against serving a DVD or thumb drive to save the environment?
Yes, you are allowed to do that. In fact, I recommend it. It will save you a ton of paper and a ton of postage. So, my usual approach is burn a DVD or send a thumb drive to serve the documents and then just drop that in the mail.
I think that is all the questions that we have for now.
Okay. All right. Well, thanks, everyone. The slides will be available afterward, and I hope you find them useful as a user manual for your own EFS filings. And if you have any questions, certainly feel free to shoot me an email. I'm at kmcnish@mcnishplc.com. And I have to give the sort of usual disclaimer. What happened today in this presentation was general legal information and not specific legal advice. But that said, certainly if you're looking for more general information, feel free to reach out and chat, and I'd be more than happy to talk to you.